Welcome back to Hashtag Lawyer, ladies and gentlemen. We are here to bring you today the 101 on how to pick a qualified judge, because we all know that picking a candidate can be exhausting. There's a lot to learn. And when it comes to judges, if you're not a lawyer, it's even harder to know what to look for. So we're here to demystify the situation for you. Stay tuned. Welcome back, everyone. You have the Legal A-Team, Austin and Andrea, live and in studio again.
Again, with a special election episode.
With a special election episode. Y'all, this is our first special episode for anything, and I'm very excited about
Milestone.
It is a milestone.
First milestone.
Yeah, I was, I had mentioned earlier that I had planned kind of a special outfit.
Right.
I thought the Rolling Stones would be very patriotic, like the t-shirt underneath a blazer, and my husband's like, that's very fun, but isn't elections a serious topic? And I was like, you're right. I'll hold off today.
I think you should have gone with it. Of course, we talked about this before the show. I'm not really the best to ask fashion advice because usually I'm just going to say, if you like it, then sure, wear it, whatever.
But I think for all the men listening, this is a great attitude to have for all the women in your life, right? Friends, business partners, whatever, great attitude.
I'll keep that in mind when my mom and sister-in-law ask about, what
Excellent.
they're wearing.
Yes.
That'll be perfect. Well, I'm glad we're releasing this, a week before the election.
Yes.
To give people a chance to hear about judges because, as we all know, judges are not the main people on the pedestal in election season.
No, everyone is understandably maybe a little bit more concerned with the presidential race.
Right.
Just a little.
And that makes, and the other offices that are up for election.
Sure, yeah.
And it's understandable we're going to be biased because we see these judges day in and day out.
Yes.
But it's really important for people to understand who they're voting for, what makes a qualified judge, like we were talking about. And so this is a really important topic to us.
Absolutely. It's important to us, and I think it's important to the community at large, right? Because you want a qualified judge when you're going before the court on a temporary restraining order or a family law matter or a business dispute. You don't want someone sitting up there and they're like, so what's hearsay again? Because that does not benefit anyone. Let me tell you.
Right. Absolutely. Absolutely. So, first point here, that's obvious to a lot of people, but some people don't realize this, but we actually do elect our judges here in Texas.
Right, which is shocking to some people.
It is, and before we get into the specifics of it, I'd like to hear, what do you think about that?
Oh, I was going to say that for the end, but we can go into it right now.
Because I don't like it personally.
Oh my gosh.
I really don't.
We are the same.
Yeah, I think, there's obviously problems with appointing judges like we do in the federal system that can still be highly political, as we see every time there's a Supreme Court vacancy.
Judge Barrett?
Right, exactly. So that's still, they're not completely insulated from the political process. The problem I have is that if you elect judges, their decisions specifically can be swayed by votes, swayed by campaign contributions. At least in the federal system, after they get past the political part, they're appointed for life unless they commit some kind of judicial misconduct.
And and for everyone listening, that's actually a really big deal to be impeached for judicial conduct. Impeach, is that the correct verb?
I don't know. Probably, but removed, whatever.
Removed for improper judicial conduct. It's actually really difficult to do.
Yeah, I've never heard of one, at least in my lifetime, that I can think of.
I can think of presidents who have been, brought up on impeachment charges. Now, the result, but I can't even think of a judge that was brought up on an equivalent situation.
Yeah, I can't either. And so you're saying you agree with me. You think that the election process of judges kind of
Yeah. So, we'll just start this episode off with a bang. Okay. So this is Andrea, slightly uncensored, right? I think electing judges, just straight up electing judges, is ridiculous and extremely detrimental to our entire community at large. And
I agree.
And the reason I think that is because, and we're going to get into this and we're going to try to remedy it with this episode, but most people have no idea what makes a qualified judge or what makes a good judge. And it's not their fault. They're not lawyers. Wow, let me just smack my microphone around. They're not lawyers. Right? If I'm getting into dangerous territory here, I don't know what makes a good referee in an NFL game. I'm guessing, and since you actually played football, you can probably speak to this better than I can, but I'm guessing that football players who play in front of these referees have probably a better understanding of what goes into making a good referee.
Right. Well, and you think about baseball is sometimes the easier analogy for trying to talk about judges. They understand this certain umpire has a certain strike zone. This umpire favors, the runner more on close calls. With judges, we tend to understand, okay, this judge likes this judge likes this. I mean, I think at the end of it all, we as lawyers want the judge to be fair.
Yes.
And part of the problem with having the public electorate elect the judge without knowing anything, I mean, you could have someone who had a case in front of the judge. It went poorly due to nothing that had, due to something far outside the control of the judge.
Yeah,
facts were
absolutely.
bad, situation was bad. That sways their vote, which they're constitutionally entitled to, do. But that doesn't necessarily weigh on whether the judge is a fair judge or a good judge in that circumstance.
Which is the most critical components or critical elements, I think, is that they're a fair judge and that they're well-versed in the rules of procedure and evidence.
Right.
To me, are the most important things. And I will say, too, something that I have noticed with a lot of my non-lawyer friends, and we're not doing it in Texas this year, which again, this is probably controversial, and I'm showing my political hand, but I think it's a really good idea. We're not allowing straight ticket voting.
Right.
And so I think that's really helpful because, and a lot of people maybe don't know this, just like when you're voting for your House rep or the president or your state rep, judges in Texas are listed with their parties.
They are.
Democrat, Republican, associated with their names, which I think completely, it's ridiculous because that defeats the entire purpose of a judge who is supposed to be apolitical and is supposed to be just a qualified individual who's focusing on understanding the facts of the case and fairly applying the law to all factual situations presented to him or her.
Yeah.
So, and I have a solution for this.
Let's go.
I do.
Let's go.
You might be the only person who likes this solution, and people might think I'm an elitist, terrible person, but I'm going to do it anyway.
Okay.
Okay. Buckle up. So, I think that since most people don't understand what goes into making a good judge, or they just don't really have, honestly, let's be real, they're super busy, have the time to do like an in-depth analysis of whether a judge is qualified or not, and have time to even learn how to like identify what makes a qualified judge, let's take that away from them. So let's have a neutral third-party organization that in association with the, State Bar of Texas, right? And State Bar of Texas, for people who don't know, is kind of the administrative body that governs all of the lawyers in Texas.
Yeah.
And for listeners who are not lawyers, for almost all judicial positions, you have to be a lawyer, right?
Right.
Except for JP courts.
Right.
Which we'll get into that another time. So have this neutral third-party organization with extremely transparent measures, partner with the State Bar of Texas, come and then have kind of like a pre-selection panel. So if you want to run for a judge, and if, say, we still have party affiliations, which I don't agree with, but whatever, keep it the same for now.
Right.
People say, oh, I want to run for judge. Let's put my name in the hat for a Republican. We'll do it for a Democrat. Okay, that's fine. Well, then this State Bar and this third-party neutral organization will go through and then have a list of publicly available criteria when they're evaluating whether this person is qualified or not. Trial experience, education, background, so on and so forth.
Yeah.
And then from there, they select the candidates that are determined to be qualified according to these nonpartisan, objective factors.
Right.
And then they're put in a primary, and people can pick from people in the primary. And then you get to the general, and at that point, excuse me, it doesn't really matter who you pick, Republican, Democrat, Green Party, Libertarian, whatever.
Right.
At least they're all qualified, which at the end of the day is really the only thing I care about.
Yeah, no, and I think that's a great solution because, and I'll just come out and say it, I mean, there's a lot of judges who, I'll just take the criminal route, for example. A lot of judges work for the state prosecution office. They come out, they go private practice, start practicing criminal defense, decide that, this is too hard. I don't want to do this. I don't want to go back to being a prosecutor. You know what? I'm going to run for judge. And some of those seats, sometimes they can be unopposed if a judge leaves the seat. And candidly, those candidates may not have enough trial experience to really do a great job making decisions on the fly in the middle of a trial. Because what happens in the middle of a trial, there's a lot of times judges can hear an argument when it comes to things like summary judgment motions or hearings that are focused on like one specific issue.
Yeah.
They can hear an argument, say, I'm going to take it under advisement, which means they're going to go back to their chambers, review the information, think about it, which is fine. They're allowed to do that.
That's cool.
In the middle of a trial, someone stands up and says, objection, this is hearsay, this is why. Judge has got to make the determination right then.
And fast.
And that determination could keep a piece of evidence out, which then could parlay or not parlay, that could sway what the jury sees or doesn't see, the storyline that they hear. And if that judge can't think on their feet, then that's a problem. And the way that judges get to where they can think on their feet is that they've been in that situation. They've sat in that lawyer's seat enough times. They've gone through it enough times. And you're right, a third-party system or third-party filtering system could really help say, okay, look, all these candidates are qualified, and so now vote your party lines. That's fine.
If you want to.
If you want to. But these people now, we know that they're qualified at least to be able to perform the job.
I think that's a really good way to put it. They are qualified to I can't even talk right now. They're qualified to perform.
Right.
Right. And I can't agree with you more, because just like you, I have been in situations, right? And mine was in civil court. It was not in criminal. But I had a judge who had, this was an area specific court, and this judge had not practiced in that specific area prior to joining the bench. And I was like, all right, well, I'm sure the judge, who has been sitting for a few years at this point, has really educated him or herself and gotten into it, knows at least the basic rules of evidence and procedure, like hearsay.
Right.
My trial in that court should have lasted 3 days. It spanned over a week because this particular judge would have to pause every time an objection about an evidentiary matter, most often hearsay, came up, and we would have to often dismiss the jury and approach the judge and argue very basic rules about evidence, meaning very basic rules as to hearsay. And a lot of evidence came in that was blatant hearsay. And hearsay is, for those of you listening that don't know, is very, very bad.
Yeah.
It's stuff that should not be allowed in at the trial. And it is not good for you if it's coming in against you.
Right.
And the judge let that in.
And that creates an issue that, say you lose, well, the only way you get to try to remedy that is you appeal it, which is expensive for the client. It takes years, all that kind of stuff. And so instead of solving the problem on the front end by having a qualified judge, you're having to spend more money out of the client's pocket, which is not good for our taxpayers because they're the ones funding all this. It's not good for them. The other part is we have certain courts that have specific types of cases they hear.
Yes.
Criminal cases only, and especially in counties like Dallas.
Yeah.
Criminal courts, probate courts, family courts, civil courts. Well, in certain other places, like Collin County, for example, up in McKinney, Plano, Allen, there's courts of general jurisdiction, means they can hear all the cases. Which some lawyers have an issue with that. I've never had a problem. What I have seen though is that there'll be certain judges that have been practicing primarily as criminal defense lawyers who then run for judge and take a seat in Collin County, for example, and then now they've got to hear family and civil, and they maybe have never done it. And that works. I mean, plug any combination you want there.
Sure.
Now, I've seen a lot of judges that get in those positions, get elected, and do a fantastic job of really working, getting up to speed on the issues.
Absolutely.
But you can imagine, I mean, you don't take a guy out of the mailroom, stick him into the C-level executive suite right away, and then expect him to understand all the different facets of the company.
Exactly. You don't expect him to perform flawlessly and seamlessly. There's going to be a lot of bumps in the road.
Right.
And look, I mean, I am sure that there are a lot of good judges who are in the position exactly as you've described, who upon being elected, pour in hours and hours of research and spend so much time talking to their, prior to the incumbent in order to understand how to best run that courtroom in the situation. And good on them. But there are some judges who won't do that.
Right.
And that's not good for anyone.
No, it's not. It's not.
No matter your party.
I agree. And it disrupts the checks and balances, too. Whenever you're being elected, I think it disrupts the checks and balances. They're supposed to be the impartial judiciary that is interpreting the laws put out by a legislature and interpreting how the executive branch carries out their orders. Electing them, to me, it vitiates some of that impartiality.
100%. I couldn't agree more.
I know we were going to talk about it at the end, but obviously we got off into it.
Gosh, we came out swinging, Austin. I hope everyone is still going to listen to the rest of the episode.
Well, I think what it does is it sets the stage as to why it's so important that we don't have a system like that.
Yeah.
So this is why it's important that we need to understand as citizens, as the electorate, what's a qualified judge look like?
I couldn't agree more. So getting into what a qualified judge is, I think we've kind of already touched on the fact that judges here are elected in Texas. They're partisan elections, just like president, federal senator, state senator, what have you. Sheriff.
Everything.
Yep. Everything. Everything, but I believe JP courts for judges require you to be a lawyer.
Right.
You have to be able to practice in Texas.
Right. So, and a lot of people, that's common knowledge to some, but don't want to take it for granted. So basically, you have to have an active bar license, meaning that you're in good standing with the state bar. There's not, and here's the other part, is that there's not a requirement for years of practice. Like there's not, an age and all this stuff. Like,
which is shocking to me.
It is shocking because, again, you would think, because I've had people ask me, which it makes sense. Like, oh, so, after you've practiced for like 10 years, you can run for judge. No. Yeah. I mean, you and I could go run for judge right now.
Yeah. Guys, I'm not even 30.
Right. And so, there's not even an age requirement, which is age, that doesn't necessarily, equal qualification, but
we want experience.
It's at least some type of a litmus test, right? Yeah,
a litmus test for experience, right? And that's really, I think, what we're trying to get at, is that we want there to be some level of experience.
Yeah, right. And so, I mean, there's not even that just to start off with.
Oh my gosh.
And so, what are, we've already touched on some of these things, but I think two of the big words that pop out to me are fair, which can be somewhat of a nebulous term, but I think to me, fair consistency is something that we've talked about a lot with this, and that's, if someone's consistent, at least they're not being partial.
Yes.
Example I hear a lot in family court is, well, does this judge like moms or dads better? Well, luckily, a lot of the judges that I'm in front of, I can say neither. They do a great job of being impartial, but that's the consistency part. There is, are they consistently being impartial? So I guess it's not just consistency; it's consistently being impartial and applying the rules that we talked about.
Yeah, I absolutely agree with that. And I have had clients ask me, whether they should try to file in, one court, or they should try to file, right? So I'm going to give a purely hypothetical example. This is not trying to discuss how certain courts lean. Someone's like, well, is it better for me to file my breach of contract case in Dallas County, or should I try and file it in Kaufman County? Assuming that they have those options, right? They want to shop around.
Right.
And so at the end of the day, it shouldn't matter where you file, because ideally all of the judges in all of our counties are qualified, and they will give consistent, educated rulings because they understand.
Justice is blind, right?
Yes, justice is blind. She's got great hearing.
She has great hearing, but she's blind. Yeah.
Yes, exactly. So, I think another thing too is how a judge runs their courtroom and their demeanor. I think that's very, very important.
Okay.
Too.
What do you mean by demeanor?
Sure. So by demeanor, I think a judge that is consistently calm. Right there, you don't want a judge who's getting excitable, banging on the gavel. Although I don't think I've ever actually seen a judge use a gavel.
Never seen a judge use a gavel.
I don't think I've ever even seen one in a courtroom.
I've seen one. I've seen decorative gavels. I haven't seen one that's actually.
Yeah, I guess maybe Judge Hoffman has one. I used to clerk for Judge Hoffman, so
I've seen a judge slam on the bench of his hand. Trying to get people to be quiet.
I have seen that before. They're like, quiet in the courtroom. Yeah.
They should have had the gavel then.
Yeah, they should have, right? Yeah. Okay.
But no, I think you're right. The calming demeanor. I mean. Personally, there's some judges you kind of get used to if they've got kind of a hyped up demeanor. As the lawyer, I can let that play to my advantage a little bit because I know the judge and I can do it. But I think overall I agree with you. They have a calm demeanor, meaning that they're keeping order in their courtroom.
Absolutely. And as part of keeping order in their courtroom, and this is probably a lot of my lawyer friends will disagree with me, but I actually prefer to have a judge that's a little bit more stern and firm, so long as he or she is consistently stern and firm with everyone.
Yes.
So, for example, it's probably really old-fashioned, but if a judge is going to require you to stand up when addressing the court, which is how I learned you should always address the court.
Yes.
And if someone doesn't do that, and the judge says, "Sir, ma'am, you need to stand when addressing the court," so long as this is just a little example, but so long as he does that consistently for everyone, I think that's good. Yeah. And he has a good handle on his courtroom. He doesn't allow people to get carried off. Sometimes lawyers like to start yelling at each other in court.
Not lawyers.
No,
do that.
never.
We don't try to talk over one another, ever. Especially not on this podcast.
No. Oh my gosh. No, definitely not.
Well, and look, you've described one judge in particular. We said we're not going to talk names. We're not going to talk negative names, negative about anything. Obviously, there's a personal reason we don't want to talk negatively about any judges.
Obviously.
We get in front of them in practice. But, we talked about Judge Moyer on this show before, and I know that's basically who you were describing there.
Yes.
You and I have a great amount of respect for him. There's a lot of controversy this year in his election because of what happened with Shelley Luther.
Yeah.
We talked about that on the show. But that is a great example of someone who is very stern, he's very traditional, but he's the same way with every single person who steps foot in that courtroom, and they get treated the same way.
He is. And he also is extremely well versed in the rules of procedure and evidence. And he consistently and fairly applies those rules to everyone. It doesn't matter if it's the plaintiff bringing forth the case. He's not going to apply the rules of hearsay more favorably to a plaintiff than defendant. He treats everyone the same when it comes to applying the rule of law. And to me, that is the biggest thing that a judge should be doing. And he does that wonderfully. Right.
So far we've talked about some things to think about, just kind of as a recap. Consistently fair. We've talked about demeanor, and we've talked about knowledge of the rules of evidence and procedure. One of the things that you mentioned a second ago, which I find hugely important, vastly underrated, is how they administer their court, the docket, so to speak. So the docket is the sequence of cases, the scheduling of hearings, how things flow through, how you receive files, how your hearings get set, all those types of things. Tell our listeners a little bit about, we deal with the frustrations of it, trying to set things. And it's hard sometimes to communicate that to our clients because it's foreign to them, especially people that work in the business world where you're in the private sector. Efficient, effective, get it done.
Chop, chop.
This is a government-run, business, so to speak. So let's talk to our listeners a little bit about some of the frustrations we can run into and why it's important for our court dockets to be run effectively by the judges who administer them.
And I think a little bit flexibly too, right? Because, and I'm trying to remember, I mean, I know we said we weren't going to get into like specific names, so I'm not going to say this judge's name, but I have a lot of respect for her. So I think, it's very difficult, right, for people to understand that when you're trying to schedule, for example, a motion for summary judgment. So for our non-lawyer listeners, that is a very usually larger, complicated motion that basically is saying the movant, so the person bringing the motion, saying, hey, Your Honor, there's not, as a matter of law or as a matter of fact, this case just shouldn't go to trial because it is so obvious that as a matter of law, this case fails, or as a matter of fact, this case fails.
Yeah, I think typically I say, like, the courts have seen enough of this type of case. The law basically says this is what the outcome is. So, judge, make a decision.
Yes.
That's a very paraphrased version.
Extremely paraphrased, yes. And so, for example, you need a little bit of time normally, you know. Sometimes, like... You have a motion, right? If it's an agreed motion for continuance because, there was pandemic and you need to extend your discovery period to the period where, for those who don't know, you're exchanging documents and deposition testimony and kind of gathering the facts about the case. If you have an agreed motion for continuance, it'll take like 5 minutes in front of a judge. Just sign it, says, okay, you agree, great. We're going to push the deadlines back by a year. Have fun. But if you're trying to schedule something big like a motion for summary judgment, sometimes it can be difficult because these courts, especially state courts in Texas, are packed. Yeah. They are so packed. And it's really difficult because a lot of times you're dealing, almost exclusively actually, you are dealing with an administrator in the court. So the court coordinator so basically the court coordinator, and you're trying to work with all of the opposing counsel to ascertain a date and a time for your hearing. And sometimes that's not for a month and a half because there's just so much on the docket. And two things I want to say about that, right, is that first, a good judge is efficient, and a good judge knows that you got to keep your docket moving. Right. You don't let things just sit and simmer on your docket. You move them so that you can give an opportunity for justice to the next person, right? And then second of all, what I was saying about flexibility. So there was this one judge, and I really like that she did this. Although the opposing counsel got into a little bit of trouble with her because apparently none of us knew this about her because we hadn't practiced in her court before. And she said, well, counsel, why didn't you, because we had a motion for summary judgment. She said, counsel, why didn't you ask the court coordinator to schedule you for I think it was like a 7 a.m. slot? Okay, the courts don't open before 9?
8:39.
8:39.
Yeah, what kind of docket you're dealing with, all that kind of stuff.
Right, yeah. So normally,
right.
around 8:30 or 9.
Right.
And this judge was like, no, I will be here. If this is a big deal. So if you need me to be here at 7 a.m. because this could potentially end the case, I will make time and I will be here to hear this motion for summary judgment. You guys better be here and you better not be late.
Yeah. Right.
But I will be here and I will hear it and I will make this happen. And I so appreciate that judge's flexibility and her conscientiousness to the parties in this case, who oftentimes trial is long and expensive and people just want to get it over with, mainly the clients.
Right. Well, and I think that this next place goes hand in hand with that because it's still part of the administration. But there are some judges we hear they don't, and a lot of times the ones that don't administer their court docket efficiently also are ones that sometimes it can take 6 months to however long to get a ruling on something simple, something complicated, whatever it is. But that's a hard thing to explain to a client that yes, we had this hearing 6 months ago. No, he or she hasn't ruled. No, I can't do anything about it. Right?
And it's oftentimes it can be critical, right? We won't get into it, but there are some things that you have to have a ruling on because as a matter of procedural rule, you can't really move forward with the case without that issue decided. Yeah. And so you're just stuck in limbo for 6 months to a year.
Right.
Because the judge won't rule.
Right.
And you can write letters. I have written letters to a judge before saying basically, please, Your Honor, just issue a ruling so we can carry on with this case.
Yeah, I mean, I've gone as far as to pop my head in and drive in, hey, Judge, how you doing? And just not necessarily mention it, but just kind of yeah, you remember me. This was let's, and then a lot of times I'll say, oh, yeah, I owe you a ruling, don't I? Yeah, you do.
Yeah, have a great day, Judge.
Have a great day. Here's some coffee, whatever. But yeah, I mean, that's frustrating because, again, and we won't get into all this. There's so many things that are hard to explain to your client because it's just the way the system is, which I hate that phrase. It is what it is. I hate that stuff because that's broken, But having to explain, yes, it's going to take us this long to get a hearing. It's because, honestly, the answer is court's not running efficiently. Yes, it's taking this long to make a ruling. Answer is court's still not running efficiently.
Right. And
that's hard to explain. That's not fair, and that's not what we want our judges to be doing. But a lot of people don't know that when they're making these votes, and then it leads to these problems that we have later on.
And it leads to backed up dockets, which is not good for anyone, especially in counties that are not like Dallas and don't separate out the criminal from the civil courts.
Yeah.
So it's
bad
even
for justice.
It's even worse there.
Right.
So, but so now that we've kind of described what we look for in a judge and our positions on the system and administration of courtroom, right? So, as a layperson, what are things that people can do to ensure that they are identifying a qualified judge when they go to vote?
I think it's never, you're never going to have the substitute for actually having watched this judge in action.
Sure.
And understanding what's going on. I think a simple, maybe a little bit too altruistic, idea is being able to talk to lawyer friends or other people that have experience in front of them. You're going to get some bias there, of course.
Yes.
But at least you can get some type of education. But I mean, there is some searching that they can do on their own. And why don't you kind of tell our listeners a little bit about what they can do to dive into some of that without the help of people like us?
Although we love to talk, so feel free to contact us or any lawyer friends. Although do know the bias is real.
Bias is always real.
Okay, so some of the qualifications, right, that people can look at is kind of what we touched on earlier is prior experience. So did that person, do private practice, right? So did they work with a law firm?
Right.
Did that person work in the public sector? Were they a district attorney? Were they an assistant United States attorney, right? So basically the prosecutor for the federal government when you're in the big boy federal courts.
Yeah.
Or big girl, not to be sexist. Were they a prior judge, right? There are some judges this year that are now running for court on the Fifth Court of Appeals here in Dallas that were prior judges in the Dallas County Civil Courts. Okay, so that's great experience.
Yeah.
That's awesome. They have experience being a judge. Wonderful. And so those are some things that they can look at because experience is huge. And
Absolutely.
And experience, not just experience in general, right? But experience in an appropriate practice area. So, Austin, what would you say if you have Susie Q, who has practiced family law exclusively for 15 years, and she is now running for a position on a family law court. And then you have John Doe, who has practiced commercial litigation for 30 years, great trial lawyer, has been to more trials in commercial litigation than Susie Q, and he's also running for the same family law bench. What would your thoughts be on that situation?
So I think there's different ways you can look at it. And so that's kind of how I'll probably answer it is I'm not going to tell you which one's better or worse, whatever.
Sure.
Different ways to look at it. So the female judge, she has practiced exclusively in this area and is running for a court probably that she's practiced in numerous times throughout her 15-year career. So she knows the ins and outs of family law. She understands it. She understands the complications that go into it. Also, within family law, it's a quasi-branch of civil litigation, so you're still using the same rules of evidence, same rules of civil procedure, all the things we talked about earlier.
Yes.
And so you're going to have a better understanding, she will have a better understanding of how does that apply to family law. Now, the other guy, he's got double the experience not in family law, so he's not going to appreciate and understand the nuances of some of the things that go on in there. One positive to that some people, and myself as part of what we do in my firm is family law, sometimes having a fresh set of eyes on the bench especially for a family law court can be a good thing. He's got the trial experience, so he's going to understand the evidence and the procedure because it's the same rules across the board there. But he may be able to provide a fresh set of eyes. And so if a voter is looking at those two things, they need to really, for their own priority's sake, think, okay, do I like the way the things I've heard about the family law system? Do I think that it needs to be administered by someone who's seen those, or are there some things that I think need to be done differently, and maybe I like this guy better because he's going to have a fresh set of eyes.
Sure. And I think, too, it's worth noting that in that example, because family law, as you said, is this kind of quasi-civil branch, it is a bit different.
Right.
We do have the same rules of evidence and procedure, but it is slightly different, and there are different versions of certain motions and things that we plead, and it's just almost a different atmosphere, if you will.
Yeah.
I like to call it the wild, wild west sometimes.
It is. It can be. It can be. We get to kind of fly by the seat of our pants a little bit more in that realm.
So, and I think, like you said, that's really important. A voter needs to make their priorities and determine, is it important for you to have that fresh set of eyes, or do you want someone who has experience and is very well versed in this wild, wild west?
Yeah.
I'm not saying one is better than the other, but you as the voter should determine what is most important to you.
Yeah.
And then take that into consideration when voting.
So I've got a question for you that I think, in my mind, there is a right answer to.
Oh, okay.
But so take the appellate court. Let's just talk about the intermediate appellate court, Supreme Court's different deal.
Do you want to explain what those are real fast?
For sure. So we've got trial court, which is where you actually try the cases. That's where the jury is. That's where the original case gets tried if you go to trial. If someone loses, wants to get that decision looked at and changed, you file an appeal. You go to this intermediate appellate court. The appellate court looks at everything, and the short version, what they're doing is to look, did the trial court make any mistakes? And
as a matter of law.
As a matter of law, I mean, there's some things they can deal with on the factual side if there's been something that's been so far outside the bounds of reason that the jury decided. For the most part, it's as a matter of law. We'll leave it there as far as that part's concerned. But basically, the appellate lawyers have to look at they're grading the papers of the trial court judges.
I like that. I haven't heard that analogy before.
And when I said appellate lawyers, the appellate judges are grading the papers of the trial court judges.
Yes.
Did they do this right? Did they do this correctly as the law says it should have been done? Do you think it matters if someone's running for an appellate court justice position? Do you think it matters whether they've been a trial court judge or not? Or do you think it's okay if they've been a trial lawyer to be able to make it up to that, to run for that second tier?
For me personally, I think it's really important to have a trial court judge.
I agree.
Because you have the experience and you have the understanding of what is going through the trial court judge's head when they're making these rulings.
Exactly.
And then when you get to the appellate level and then you're grading your former colleagues, as you would say, you understand what they're thinking. And you also understand, I think, the temptations for them to maybe make procedurally incorrect rulings.
Agreed. Absolutely. 100%
and you're aware.
Agree. 100% agree, because you've played the game.
Yes.
You understand how it goes. And I would even add to that, too, because I think that's a great point, but I just thought of this as we were talking. The other part is that if you've been a trial court judge for a while, you at least have some practice of impartiality.
Yes, that's a very good point.
Us sitting as the lawyers, we are supposed to be biased. That's our job.
We're literally paid to be biased.
Right, for our client. That's what we're supposed to be doing.
Yes.
The other side's doing the same thing. Trial court's there to pick up the pieces and figure it out. Trial judge. if you've been a trial judge for a while, you've been in that position of sorting through the BS and figuring out what the answers are. So you've kind of had that practice to then go to the appellate level and on a much bigger stage do the same thing. So I agree with you, and I think those two factors are really important when we're talking about qualifications, and they're not currently in place when people are deciding to run for appellate court judge positions.
Which is very frustrating.
Right.
Yes.
That's why it blew up at the beginning of this.
Yeah, it is. It is why we blew up at the beginning of this.
Now, I saw this is something we talked about right before we went on, and I actually candidly hadn't heard of this before. But the CQJ that you had talked to me about before the show started. Talk to our listeners a little bit about that, because this is interesting to me.
Yeah. So this is a nonprofit third-party organization, and I'm assuming there are several of them around the state, if not the country, right? And CQJ is the Committee for a Qualified Judiciary. And so and I'm going to paraphrase their mission statement, right? So generally what the CQJ does is that it sends out questionnaires to the judicial candidates running in Dallas County and determines, based on the answers to this questionnaire, right, if they're qualified or not. And so the CQJ questionnaire is actually quite long, and they look at evaluating this individual's educational experience, their trial experience, their practice area experience. Do they have any disciplinary history? Were they ever had their license suspended? What areas of law did they practice in? What percentage of their practice was in federal court? What percentage was in state court? What percentage was in criminal court? So on and so forth. So they do a very in-depth dive into determining the manner of practice for the individual, their experience, their practice areas, and these are just a few variables.
Right.
And so then they take all of these variables and essentially determine from these, I think, very objective variables, whether or not that judge is qualified for the position that he or she is running for.
Wow. And you listed off quite a few of the variables that you discussed at the beginning of the show that we talked about. These should be part of a pre-determination or a pre-vetting committee. So is this, and I don't know this either, is this a statewide thing? Is this?
So and y'all can fact check me, but I am pretty sure that the CQJ is limited to Dallas County.
Okay.
I think.
Well, I think that's an awesome idea. This is something I definitely want to research it more. I think our listeners should look into it, because it at least gives some form of measurement to the electorate to figure out something quantifiable.
And it gives them an efficient way, right? Because, a lot of the things that we were discussing earlier, the trial experience, prior experience, practice area, that's, if you just Google the candidates, oftentimes that information is available on their website. But I feel like the CQJ essentially gives you an efficient, almost free way to determining whether or not a candidate is qualified.
Yeah. Well, and it's an impartial way to figure out if the candidate's impartial.
There you go. An impartial way. I like that.
Because obviously, if you look on the candidate's website, they're going to sound like the greatest trial lawyer the state's ever seen.
It's like the highlight reel on Instagram.
Right.
It's like that.
Right. It's the same kind of deal. Same kind of deal. Yeah. Campaign websites, social media posts, same thing.
Yeah, absolutely. And so, guys, you can just Google the Committee for a Qualified Judiciary. It should pop up right away. And then if y'all are interested also in the questionnaire, that is also available on their website. So people can read, if they want, in depth on the questionnaire and see each of the variables that the CQJ considers when making their determination.
Yeah, and we can put this in the show notes too, so
absolutely.
people can see kind of some more, just in case you forget the name and all that kind of stuff.
We can totally do that.
I think kind of as a recap to some of the big factors we talked about, we want people who are consistently fair. We want a judge who's got a demeanor that is professional to the courtroom.
Yes.
And we want a judge that's going to efficiently run their docket, run their rulings, and that knows the rules of evidence and procedure. And I think tied into that, knows the area of law that they're going to be ruling on primarily. And I think that it's so important for people to look into those things as opposed to doing the party line stuff. Yes. I know we already talked about this, but I think it's important to stress that again.
I can't stress it enough. The party line, y'all, the party line does not matter when it comes to a judge.
Right.
Like I routinely vote for judges that are not, technically in the same party as I consider myself.
Right.
And I vote for those judges because I think that, based on my experience in their courtrooms, that they are excellent judges and that they are always prepared. They meet all of these variables that we laid out, and they're they've read all the motions, they've read the briefing that the lawyers submit, and they are ready to dig into the finer points of procedure and evidence that are at issue, whether it be a hearing or a trial.
Yeah.
And they move their dockets quickly.
Yes. Love that.
Love a quick docket.
Well, and so I'm glad that we walked through all these things because, again, we talk about this. The sexy side of election season is the executive branch, whether you're talking president, even I mentioned the sheriff earlier. I mean, those get more attention, far more attention than the county court judge running for their seat, you know, in a small county in rural West Texas. You know?
But it makes a difference. It makes such a big difference.
Makes a big difference.
You guys do yourself a favor, right?
Absolutely.
And pick a qualified judge.
Yeah, absolutely. And obviously, you know, I'm not trying to act like we're big influencers here or anything like that, but go out and vote. Go out and vote. You know, obviously, go take care of that.
Go out and vote. And, you know, let me just say this. Like, I feel like I've been, and I don't mean this badly, like kind of beaten over the head on Instagram with, like, go out and vote, which is, like, great. All my friends are registered to vote, and pretty much all of them have already done early voting. Yeah. But I would like to, and I wish, like, all of these influencers who are telling us to go vote on Instagram would also add the caveat, go out and make an informed vote.
Yes.
Make an informed vote. Do yourself a favor. And frankly, I think it's your civic duty to not just vote straight ticket, but instead put a little bit of effort into determining if the individual you are voting for, president, sheriff, judge, is, based on the factors that you can tell, qualified for that position.
Yeah, absolutely. And that's what we're trying to do with this episode, is to help educate our electorate. So one thing I am excited about as we close out is we've got a follow-up closing argument that I'm excited for you to drop some information on our listeners for.
Yes.
So they definitely need to stay tuned and listen to that part.
A little bit of F Factor drama getting real. Fantastic. Oh, stay tuned.
Happy election, y'all.
Happy election.
Thank you guys again for listening to us here on #Lawyered. Go find us on whatever platform it is that you listen to your podcasts. Go like the podcast, go follow and subscribe to us. Leave us a review, leave us a rating. That helps us to really get the word out and really continue to tell you guys about all the different things that are going on in law and business here in Dallas. Make sure you check out our videos on our YouTube channel. It's #Lawyered. And then also follow us on our Instagram account. It's at #Lawyered. DM us, send us some issues, some topics you'd like to discuss, or some things that maybe you just don't understand about the law, because we want to make sure and cover and give you what it is you want to listen to.
So glad that you guys stay tuned, because the drama is real with F Factor, y'all. So y'all remember episode 18 where we described the drama between F Factor and its founder, Tanya Zuckerbrot, and the influencer Emily Gillis-Land, where she was posting allegations that the diet powders and bars from F Factor were causing severe health causing severe health reactions in women all around the country. Everything from breaking out in hives to miscarriages. So this drama has now actually become very real. There is a lawsuit that is now filed in state court in New York with Tanya Zuckerbrot and F Factor, the company, as the plaintiffs, suing Emily Gillis-Land in like a 50-plus page complaint. And they are suing Emily Gillis-Land for product disparagement, defamation, which, hey, called it in episode 18, DTPA, so deceptive trade practices, intentional infliction of emotional distress. That's a good one. Yeah, that's very interesting. And civil harassment. So stay tuned, y'all, and look into it. And also, these documents are publicly available if you want to go read. Enjoy.